Divorce can be one of the most challenging experiences of life, but how you choose to navigate that journey can make a big difference. There's no one size fits all answer to how a divorce should unfold. Today, we're going to explore the different methods of divorce and help you find the right one for your situation. Hi, I'm Renee Turner, the founder of Thoughtful Lawyering, a New York based law firm that provides accessible, easy to understand legal information for educational purposes only. The information provided in this video is not intended as legal advice and does not establish an attorney-client relationship. For advice on your specific legal situation, please consult a qualified attorney. In this video, we're going to break down the different ways to get divorced. There are several options available to couples, ranging from the most amicable to the most contentious. Whether you're just starting to think about divorce or already in the process, understanding these methods can help you decide what works best for you. So let's get started. First up is mediation. Divorce mediation involves a neutral third party called a mediator who helps both spouses communicate and negotiate the terms of their divorce. The goal is to reach an agreement without going to court. It's important to note that a mediator is not always a lawyer. The person just needs specific training in mediation. The mediator doesn't make decisions for the couple or impose solutions. Their role is to help both sides communicate and focus on their needs and interests rather than getting stuck on specific demands. The process typically starts with an orientation session where the mediator explains the mediation process, including its costs, the mediator's role, the importance of obtaining independent legal advice, and that mediation is not a substitute for legal advice. During the mediation sessions, the mediator helps both parties understand their situation, discuss the main issues, and create a plan to address them. Mediation is confidential, which means anything discussed cannot be used against either spouse in future court proceedings. This encourages open and honest communication. The mediator's goal is to balance the negotiating power between both sides to make sure the final settlement agreement is fair and voluntary, rather than the result of pressure. If an agreement is reached, the mediator drafts what's called a Memorandum of Understanding, or MOU, that summarizes the resolution. This document isn't legally binding, but can serve as the foundation for a formal settlement agreement, which can then be reviewed and finalized by both spouses' lawyers. If no agreement is reached, the mediation process simply ends with no further obligation by either spouse. Mediation is ideal for couples who are willing to collaborate and communicate openly. It's usually faster and less expensive than a contested divorce. Plus, it's a private process, which means less public exposure. The advantages are that it's generally cheaper, quicker, and less stressful, but it might not be the best option if there's a history of abuse or extreme conflict between the spouses. If both parties are open to compromise, mediation can lead to a more peaceful resolution. However, if either party is unwilling to negotiate, it might not be the right choice. Next, we have collaborative divorce. This method involves both spouses hiring their own attorneys, but instead of battling it out in court, they work together to negotiate a settlement. It starts when both parties sign a collaborative law participation agreement, committing to settle their differences without going to court. This agreement includes a promise from both parties and their attorneys to work together in good faith to reach a fair, mutually acceptable settlement. In a collaborative divorce, a team of professionals are involved, including the attorneys, a mental health professional, and a financial expert. Together, they address the legal, emotional, and financial aspects of the divorce. Everyone on the team is trained in collaborative law and agree to withdraw if the case goes to court. This keeps the focus on open communication, transparency, and cooperation between the spouses. During the process, both spouses share important information like financial documents and asset valuations in a confidential setting. The goal is to negotiate a comprehensive settlement that covers everything: property division, child custody, child support, spousal support, and any other matters related to the divorce without court involvement. If the collaborative process ends, either by one spouse's decision or by initiating court proceedings, the collaborative attorneys and other professionals involved must withdraw, and the spouses have to hire new attorneys for litigation. This encourages both spouses to stay focused on resolving the divorce outside of court. Collaborative divorce is best for couples who want to avoid the courtroom but still need legal representation. It's a cooperative approach, but if negotiations break down, you'll need to hire new lawyers for a contested divorce. So while it can be effective, it can also be more expensive. Collaborative divorce has several advantages. First, it keeps the process out of court. Second, it allows you to address complex issues with experts. And third, it's more cooperative than litigation. The downside is that it can be expensive, and if the process fails, it may require starting over with new lawyers. Next is an uncontested divorce. An uncontested divorce is one where both spouses agree on all the major issues, such as child custody, property division, child support, and spousal support, without needing a judge to decide for them. Since all issues are resolved through mutual agreement, there's no need for a lengthy court battle. The court will simply review the agreement, and if everything looks fair, issue a judgment of divorce. To get an uncontested divorce, both spouses must agree on key issues, like the desire to end the marriage, the division of property, spousal support if that's applicable to your divorce, child custody and support also if that's applicable. And they also must agree on the legal grounds for a divorce, which is usually irretrievable breakdown of the marriage. There are many benefits to an uncontested divorce. It's usually faster and cheaper than a contested one, since both spouses agree on all terms and avoid lengthy legal procedures like discovery, depositions, and court hearings. Instead, you'll file the necessary paperwork with the court outlining the agreed upon terms. If the court finds everything fair, it'll grant the divorce. An uncontested divorce gives you and your spouse more control over the outcome. You directly negotiate the terms, unlike a contested divorce, where the judge makes the final decision, adding some uncertainty. Typically, the first step is drafting what's called a marital settlement agreement. This document is a legally binding contract that outlines how all divorce-related matters will be handled. You'll negotiate with your spouse or their attorney to finalize this document. If everything remains uncontested, the next step is preparing and filing the necessary court paperwork. This two-step process keeps your divorce simple and cost-effective. The major advantages of an uncontested divorce are that it's typically faster, less expensive, and less stressful than a contested divorce. However, it's only possible when both spouses are fully in agreement, so it's not the right option if there are disagreements. Next is a contested divorce. A contested divorce is when you and your spouse can't agree on important issues like property division, child custody, child support, or spousal support. This is when the case goes to court and a judge makes the final decisions. A contested divorce involves several steps, which can vary depending on where you live. Generally, the process begins with the filing of a summons and divorce complaint, followed by an initial case management conference. At the conference, you'll identify the issues that you and your spouse disagree on. In contested cases, both parties usually need to submit financial forms and statements. The court might also schedule what's called a pretrial conference to clarify the issues in dispute, to identify any facts that you agree on with your spouse, and to set deadlines for discovery and other hearings. During the trial, the court will hear testimony from both spouses and any witnesses. The judge will then make decisions on key issues like property division, child custody, and support based on the evidence that's presented. A contested divorce is often necessary when there's a breakdown in communication or major disagreements. It can be lengthy, stressful, and costly, but ensures that a resolution will be reached, though you might not get exactly what you want. The advantage of a contested divorce is that the court will make the final decision, but the disadvantages include high costs, a public record, and potentially emotional distress. Last is a default divorce. This happens when one spouse files a contested divorce, but the other spouse doesn't respond or show up in court. This allows the spouse who filed for the divorce to request what's called a default judgment, which the court may grant under certain conditions, such as proper service of the divorce papers and the court having authority over the case. The impact of a default can vary depending on where you live. Generally, if the spouse who didn't file for divorce doesn't respond, it's seen as an admission of the facts in the complaint. However, this doesn't automatically grant the divorce. The spouse who filed for the divorce still needs to provide evidence to support their claims. Once a default judgment is entered, it's legally binding. The terms, like how property is divided, become enforceable. However, the spouse who didn't respond may still have a chance to challenge the judgment, especially if they can show a valid reason, like improper service or other special circumstance, as to why they didn't appear in court. So while a default judgment can speed up the process, the spouse who didn't respond still has some options to fight it depending on the situation. As you can see, there are many paths to divorce, each with its own set of pros and cons. The best approach depends on your specific situation, such as how much you and your spouse can agree on, your financial resources, and the emotional toll you're both prepared to handle. Ultimately, the goal is to find a solution that works for both of you and helps you move forward. Remember, divorce doesn't have to be a battle. By understanding the options available, you can choose the one that suits your needs and helps you start the next chapter of your life. At my law firm, Thoughtful Lawyering, we specialize in drafting marital settlement agreements that outline your desired outcome for the divorce. Nearly 90% of all divorces, whether resolved through mediation, collaboration, or contested, are finalized with a settlement agreement. As an experienced family law attorney, I can help you create an agreement that prioritizes your best interests and protects your financial future. To learn more about the service, simply click the link in the caption. If you're unsure which divorce process is right for you, feel free to schedule a clarity call with me using the link in the caption. I'll answer your questions and provide guidance on the best approach for your specific situation. Thank you for watching. If you found this video helpful, don't forget to like and comment, and I'll see you in my next video. Bye.